Hello again, everybody, and welcome to another edition of the Inside Lowell Daily Pulse, the Thursday, June 19th edition of the Daily Pulse. It's Juneteenth, a holiday out there, and I hope you're all getting the day off, unlike myself and my guest today. Hopefully you get the pleasure of enjoying the day a little bit with friends, family, and also hopefully you celebrate the day itself and the spirit and what it means in our history. We've got a special guest in the WellPoint studios with us today, Dan Shanahan, a rather, dare I say, well-known local attorney.
I wouldn't say well-known, but known enough.
Known enough.
Certain circles.
Because,
sure.
you became kind of a recurring character during my radio career. Or should I say, maybe not necessarily you, even though you did run for school committee one time, but your hair. Oh. You became known as the hair, thanks to your buddy Batch, of all people.
Batch and Asa, yeah. They ran that one into the ground, but sure.
And of course, my radio audience didn't really understand. But I mean, if you look at him now, my podcast audience, look at that over there.
It's probably got a lot more gray since the radio days, but I can still comb it.
Exactly. That's what I keep telling people. Like, my hair might be messy, but it's there. I still have it. But anyway, we got I was going to come in and annoy people by myself today and just do kind of a show recapping the Karen Read trial now that the verdict finally came in yesterday. And just coincidentally, you texted me and said, hey, if you want somebody to talk about,
if you need someone to help annoy people, I'm available. It's a holiday, but the law doesn't sleep. I'm here.
Yeah, well,
no days off.
You can. If, I don't know. You'll probably annoy the people who thought she was guilty, maybe, but you can do so with your legal background and expertise, and you can also help explain, because there were some things even as the verdict was being read yesterday that I was kind of scratching my head, going, huh? What? And you were telling me off air that your wife was asking the same thing. Like, what are they doing with this particular thing here and there?
Yeah, the video, the soundbite sounded very awkward when the clerk was asking them to read their verdict, and they weren't sure what to do, it seemed like. And again, I did bring in a copy of the verdict slips, and I checked the boxes off as best I could based on what we know what the verdict was. The actual slip that was signed by the jury has been impounded. Apparently, so it's not, it's
but
not
you have.
But I have copies of the actual blank slips that was submitted. Those were public.
Yeah, dude, that's show prep. I don't do show prep. I wrote a couple of questions on a sheet here. You're gonna make me look bad.
Well, I wanted to catch up because I wanted to actually clarify for myself, like, what were the charges, and what was she potentially looking at, and what did they ultimately find? And kind of jumping the gun, what we did find is probably the most expensive OUI conviction in the state history. But,
the instant joke that came out yesterday. So we're going to get right down to it with local attorney Dan Shanahan in a quick second. Let me just thank our Daily Pulse sponsors, Ray Booten, licensed realtor in Massachusetts and New Hampshire, certified appraiser in both of those states as well. So if you're looking to buy or sell a home, a business, or a commercial property, the man you need to talk to, the person you need to talk to, is Ray Booten. And you can find him online, realestaterayBooten.com. That's realestaterayBooten.com. You can bet Ray was celebrating yesterday. He was a huge supporter of the Free Karen Read movement. I don't know where the WellPoint folks stand, but I know they're huge supporters of Inside Lowell, and we're coming to you here from the WellPoint studios. WellPoint is the only health plan offering healthcare benefits exclusively to GIC members. At WellPoint, your whole health is their whole point. Thank you to WellPoint. Thanks to Ray. I'm going to thank a couple of other sponsors in a little bit, but let's get right down to it with our guest, Dan Shanahan. All right, so the first question, and the one that will probably still be debated, because I feel like the Karen Read case was kind of like our courtroom version of the president. And either you love him, you hate him, and no matter what the issue is, no matter what the information is, people have their mindsets, and you almost feel like you're living in two different worlds when you see the analysis of the presidency. I kind of felt the same way in this trial. You'd see the same person testify, you'd hear the same words used on social media posts, but some people use those exact same words to defend Karen Read. Others use them to say she was guilty as sin. So the question is, let me ask you, Dan Shanahan, did the jury get it right yesterday?
I believe they did, based on the evidence. And again, they're not they don't have the benefit of hearing everything that the rest of us hear. You know, there are particular rules of evidence that guides what can go into the case and what the jury can consider when they're deliberating. And then they take those facts, what the evidence is, and they have to apply it to the elements of each criminal charge. And, you know, this jury obviously took their time. They deliberated, you know, part of the day on Friday, all day on Monday, all day on Tuesday, came back with some interesting questions, some intelligent questions, which to me, you can tell they were paying close attention. They gave this a lot of thought and a lot of deliberation, and ultimately came back with a verdict yesterday that, again, has to be unanimous and can't always be easy, especially in a case that had a hung jury once already. But I believe they got it right.
Yeah. It seemed, based on the questions they asked of the judge on Tuesday when they brought everybody back into the courtroom, I instantly, my mind said, all right, they're not going to convict her of anything that's going to put her in jail, but they do think that she was operating under the influence, but they wanted to make sure that if they said guilty of that it wasn't going to put her in the slammer. Did you read it the same way when you started hearing those questions?
I did, and all, you know, people, attorneys, they all do the same thing in a jury trial. When the jury is out deliberating and when that question comes back, you always try to read into it. Where are they going? And it can be a roller coaster ride, and I believe that happened here. Like one question, you think, okay, the jury's leaning this way. Then they come back with another one and kind of deflates your bubble a little bit. But yeah, based on the questions that I heard, I felt like they were clearly beyond the murder charge, and were on to the OUI and the several lesser included charges that came with that manslaughter OUI charge.
All right. I want to talk a little bit about the legal process, because you said something is, remember that the jury didn't know everything that some of the people who were following it through the media might have known. And I'm curious why that is. You know, we all, if you're old enough, you grew up watching Perry Mason, or you've seen a movie, you remember A Few Good Men, or any good legal TV series or whatever. So we all think, you know, that it should go just like it does in a Hollywood script. But I was particularly interested in why the jury was not allowed to know that the experts, the reconstruction experts and the forensic experts that the defense were using, were actually in a lot of ways originally hired by the feds as part of a federal investigation. And there was like, you know, back and forth about, you know, the defense team was paying them, and they tried to make a big deal out of that. But in reality, the ARCA, was that
I believe
is that the
so.
group that the
Yeah.
it's like, and it's supposed to be the gold standard for forensic and, you know, murder and accident investigations or whatever throughout the country. They were brought in as part of a federal investigation into what happened that night, and the jury was not allowed to know that. Why?
Well, I think in part because, again, that now opens the door to other issues that aren't relevant to the case. Why was there a federal investigation? And if they hear that, they're going to wonder, well, what were the results of that? Did it compromise this case? What effect did it have? So the judge is the gatekeeper of the evidence when presiding over a trial. And there are rules of evidence. The judge is given some discretion. So I believe in this case, the judge weighed whether or not it's relevant, or is it probative, or would it be unfairly prejudicial to the other side if that type of evidence is let in. So my best guess would be that she felt it wasn't relevant to this case, to the charges against this defendant, and in part it might unfairly bolster the credibility of those experts, because if they've been hired by somebody else. Although in my view, I think that can be, you know, fair game. I think that allows for, you know, the credibility. You want to bolster the credibility of your witness.
Because part of the thing is the jury's hearing expert witnesses from the prosecution saying this is exactly how it happened. And then you're hearing expert witnesses from the defense saying this is exactly how it could happen. And the two of them are completely different. So now you've got to judge as a juror, well, which one is more credible? And if I'm thinking, all right, do I believe the guy, you know, the feds, or do I believe the guy who's been in college for longer than I've been in media? It's like, who do you believe? Who's more credible? and yet that didn't, that didn't come up.
And I'm sure the defense team had objected at the time and preserved it. And if the case went south for her, I'm sure that would have been one of the issues on appeal, that did the judge abuse her discretion in precluding, that type of background history or on those experts. So.
Now, what's interesting about that is I feel like in the first trial, given the fact that the defense seemed to almost put as much stock into the alternative theories for how John O'Keefe died as they did the forensic evidence, that having the question of, well, there's a federal investigation going on, would have completely played into their hands, because the jurors would have said, somebody else legitimate thinks that there's something going on. But based on the fact that the feds didn't bring charges, before the second trial, that would have killed any of their, maybe the jury says, okay, that's why they're, this isn't plausible, because the feds investigated and they didn't find anything in that house. Do you think that's why the defense didn't completely ignore the house and who was in it and what happened that night in the second trial, as opposed to the first trial, that would have brought some things in that, nobody else found credible?
Yeah, perhaps. And again, everyone's having a second bite at the apple in this second trial, right? And I'm sure both sides canvassed this case, probably had mock juries. How did these issues work? How did these issues play out? How would a jury react to this theory? And you did see both sides kind of alter their theories of what the cause of death was or what she was doing. And you saw a lot more science, I think, in the second time around, with kind of the battle of the accident reconstructionist versus the first time there was the big conspiracy theory and the cover-up. So, I think they revisited it, and it was just a strategy.
All right. You mentioned the verdict slip. You brought it on in. It was fascinating, as we all been waiting breathlessly for this verdict to come in, that when it came in, there seemed to be a lot of confusion between who is it, the bailiff who kind of is calling out the instructions, and the jurors, and then a couple of times you heard the judge interject to kind of clarify something. Why was there so much confusion?
I don't know why there was so much confusion. I will blame the clerk, but in a typical situation like that, when the jury has a verdict and they return back into the courtroom, they're all asked to stand. There's one foreman who speaks for the group, and then the group has to, concur with what the foreman says. And there is a procedure that the clerk will then read each charge and ask the foreman of the jury, how does the jury, answer that particular question? And if you heard some of the language, they still follow some of the old school kind of hearken the jury and that old language. Mm-hmm. But perhaps they just weren't given enough instruction. Like, when you come out, this is going to be the order. This is how we're going to ask, and this, you respond yes or no. It didn't seem like there was enough instruction for when they came back out how to appropriately respond so that it's in the record appropriately.
Was the verdict slip itself confusing? Did that lead to some of the confusion? I almost felt like, they kind of had to, once they get to the lesser charges, and then there were charges beneath those that may come into play. I got kind of confused, and I'd like to think I'm somewhat educated on this stuff.
And I believe the jury was confused because the way the verdict slip was set up, and specifically with the second offense, which dealt with the manslaughter, and the OUI, which is operating under the influence, within that were lesser included charges where they would either, check a box if they met the elements of that crime, and if not, they would just move on to the next. So when you see the final verdict slip, there would be unanswered questions, and you have to flip the page to find out whether or not they eventually did mark a box. And then it relates back to the general question for question 2. And I think that's where it got confusing, where, right, she's not guilty of this, this, or this, or this, but she was guilty of this, and then it relates back to question 2, and the way it was worded is, guilty of the offense as charged. So it was a very kind of awkward verdict slip, a little difficult to follow, so that could have caused some of the confusion.
Was it the same verdict slip as the first trial? Were the charges exactly the same, and were they laid out and spelled out the same way for the jury to consider?
That, I don't know. I didn't compare it. I didn't take a look at the first verdict slip, but I know that it's the same attorneys, for the most part, involved. Second trial, and it came to a point where on the second charge, they actually, based on the jury's question, they had to amend that slip and make it a little bit easier to follow, because it was obviously vague, or there was some confusion there, and even still it seemed like there was some confusion.
All right, you joked about it being the most expensive OUI conviction in the history of the
That I'm
legal
aware
system.
of. Yeah.
I don't remember that being an option in the first trial. Was it just a strict operating under the influence? I don't, because I would think that would be the one thing the jury might be able to unite on that was hung on everything else. But I don't remember that charge. And how do you charge somebody with OUI when she wasn't cited for that night, right?
And she doesn't necessarily have to be cited for it right then and there. If there's, usually that's the most compelling evidence. If you have a traffic stop and a police officer, on scene, witnesses someone operating impaired, and the field sobriety test or a blood alcohol test confirms that they're under the influence, then you bring charges. But it's almost like the what they call the fruit of the poisonous tree, right? If you start one investigation and you uncover evidence, if there was enough evidence there to bring a charge of operating under the influence, then they were well within their right. It was all, again, as part of the initial indictment, if that's a lesser included charge, in the second offense, which was manslaughter while OUI, then it was permissible for it to go to the jury. I don't know if that was a part of the first trial. Again, there seems to be some confusion. I've never looked at the slip, and now you have me curious that I want to, because
that's your homework assignment.
Because we didn't really get to see that, because my memory is it was just a mistrial. It was hung, so we didn't get to see what they answered. And what we learned after the fact was, supposedly some jurors spoke out and said, hey, we would have been unanimous on, finding not guilty on the murder, but we were hung on some of these other charges. And post-trial is when they were trying to get, the most serious charge dismissed based on how the jury was, responding to feedback. But we never really saw how far they got and what questions they either answered or were asked to answer. So I don't know if the OUI, the straight OUI charge, was actually laid out as a lesser charge in the first trial.
Should the prosecution have brought a second case forward after the first hung jury, and then some of the info that came out afterwards, that it didn't seem the jury was at all interested in convicting her of second degree or maybe even manslaughter? Did they drop the ball bringing the second case?
I believe the district attorney had to. I don't believe they had a choice. Where you have a death like this, and there's a hung, so it's not a loss. It's not a win, but it's not a loss. So there was certainly enough evidence for it to go to the jury in the first place. And they were obviously hung up on something. So no, I think they did the right thing bringing it back. And in my opinion, they should have revisited, really realistically what the charges should be. But then again, it would have been a bad look, because now you're dropping murder charges. Why is that? What has changed? So they were the second team was sort of locked in to what the first team did.
All right. We're chatting with Dan Shanahan, local attorney here. Want to give your law firm a plug? Come on, let's go.
So yeah, I'm of counsel at 𝐃𝐚𝐢𝐥𝐲 Legal Group, which is just a boutique firm down in Wellesley. I do personal injury, family law, but one of my niches is I do insurance defense and liquor liability cases, defending bars, restaurants, which is why I have a particular interest in this case, because of the intoxication allegations, what the group was doing. Everyone has seen the videos of them being at the bars.
Sure. And because of the civil cases that are still to come, which we will get into. First, let me thank all of our Daily Pulse sponsors: Ray Booten, licensed realtor in Massa, New Hampshire. Find him online, realestaterayBooten.com. Thanks as well to our friends at WellPoint. At WellPoint, your whole health is their whole point. Washington Savings Bank, banking that goes the extra mile. Make the switch now to Washington Savings Bank. TMI Properties, quality and value at every price point. Find your perfect space with TMI. Mahoney Oil, providing warmth and protection to Greater Lowell and Southern New Hampshire since 1925. The Greater Lowell Community Foundation, improving the quality of life in our communities through strategic, impactful philanthropy. Francis C. Preventure Insurance, the agency Greater Lowell has counted on since 1982 to protect its most valuable assets. And by the Massachusetts Pirates, bringing all the hard-hitting action and excitement of arena football to the Mill City this Saturday night, June 21st. Pirates at home against the Tulsa Oilers. Big game for the Pirates, who are riding a 3-game winning streak. They're back in the playoff hunt and could go a long way towards securing a postseason berth with a victory this Saturday night. We return to Dan Shanahan here. All right, as an attorney, I'm gonna ask you to grade the attorneys. All right, first, the defense team. I feel they changed strategies completely. The first trial, they almost focused as much on the alternative theory and what happened in the house. The second trial, they went right for the science. They touched a little bit with Jen McCabe on, what was in the house and that maybe something nefarious happened in there, right? But they clearly learned from that first jury what was effective and what was not, didn't they?
They did, and I'll admit I didn't watch it all that closely as some of your guests have watched it. I guess I have a little less free time, but my general impression is the defense team, I would probably give them a B minus on the second trial. They certainly were going up against a better prosecution team the second time around, and oftentimes that kind of raises your game as well. I do appreciate the change in the defense theory, and that obviously worked. What I disagreed with was letting their client, give so many interviews and speak so freely, knowing that there was going to be a retrial and that was going to be admissible.
That was stunning. And if she had been convicted, I think everybody would have pointed to those interviews and her de facto testimony when she didn't have to say a word until after all of this was over, right?
Yeah, and during a jury trial like that, trust me, the jury is paying attention to all the body language, how the attorneys are reacting, how the defendant is reacting. And if a defendant does take the stand, they're obviously watching very closely what that witness's demeanor is on the stand. That's the face of your case. So in the criminal trial, they wouldn't have really got to really know her, but just see her and not hear her. But having those interviews, they got to see, maybe a different side of her. And maybe she wasn't the most likable person after those interviews or the most sympathetic person. And that could have compromised, again, what a jury was thinking. It's not necessarily relevant evidence, but, you can't put the toothpaste back in the tube, right? You let that out, jury kind of sees it. Maybe they're a little less sympathetic and think, yeah, maybe she was capable of doing something, or something happened that night. So it does go to her credibility and the credibility of her case, but ultimately the jury weighed all the evidence and found, not guilty on the more serious charges.
All right, so you're a tough grader. You only gave a B minus to a team that's being universally lauded out there for getting a hung jury in the first case and then outright getting their client off yesterday. If they're only getting a B minus, what does Professor Shanahan give Hank Brennan?
Well, again, I'd give him a C plus. I think they were pretty evenly matched. I do. It's, they were given the facts that they had. The prosecution didn't conduct the investigation. They didn't choose who the players were going to be. The second team that came on had the police reports, the police investigation, and the witnesses that were interviewed, and that's what they had to deal with. So I think given what they had and some of the changes, in their strategy, again, they were behind the eight ball. They had a lead investigator who had since been terminated from the state police, and they made a tactical decision not to call that person. They put the next best thing, which they thought was going to be on Buchanan or something.
Everybody calls him Bukaki now. That guy's
this is internet. I think
he's going to live with that the rest of his life.
And I don't think he made a very impression on the jury. So again, I'll give them a C plus. Given with what they had, I think that they did the best that they could. I think he had a generally a good style, and I thought he presented the case as best he could. So
you said the prosecution did a better job the second time, Hank Brennan versus Adam Lally. A number of people have said that. If I'm Adam Lally, I'm like, hey, I got to a hung jury. You guys have this woman walking the street. So in retrospect, was was it $250,000 that Hank Brennan got to be the special prosecutor, or whatever it's costing the taxpayers? It might, maybe more. Now, maybe now I'm thinking it's $450,000. It cost the taxpayers a lot of money for this trial, especially the second trial. Was it smart to have a guy who was a kind of a defense attorney Hank Brennan come in and prosecute a case?
I think it's helpful because they can appreciate the defense perspective, maybe what they would be doing. And especially you're going first as the prosecution. So, you're putting on your case first. You have to kind of anticipate, okay, where are they going to try to discredit my witnesses on cross-examination? And having that perspective, perhaps he could try to head some of that off. And I think you did see and hear that in some of the interviews where they put some bad evidence in, put it out there so that there wasn't any surprises, and the jury's not hearing it for the first time on cross-examination, now thinking, hey, the prosecution must have been hiding that. So he had to come out with some negative evidence during their case in chief to kind of head it off and try to cure it as best they could before cross-examination. So in my view, I think that gave him a better perspective on how to play both sides and perhaps where the defense might be coming from, because I think everyone agreed that there were going to be different theories and different strategies the second time.
All right. Prosecution, do they get an F? And by prosecution, I don't mean the attorneys, either Lally or whatever. You kind of alluded earlier. Look, they were handed this case. They were handed the investigation, the way it was conducted, and the cast of characters who were in that house, in that neighborhood that day, and while the investigation was going on. Did they really like butcher Michael Morrissey, the DA? Is he the guy who ultimately should take the blame?
In my view, yeah. And you wonder, does politics come into play? It's, he's an elected official. Why move forward? Why be so aggressive on these charges? Which, at the end of the day, I think everyone saw, at worst was an accident, was a terrible accident and a tragedy. So yeah, I feel like that the district attorney who makes the final decision, what the charges they feel, should be brought. And I think he was overly aggressive. And in the long run, in my view, I think that discredited their entire case.
It also hamstrung the attorneys who were actually in the courtroom, because now they've got to go out and prove what is a weak and questionable case.
Yeah, they don't have a say in that. And yeah, they have to now prosecute to the best of their ability, whatever the charges that were brought against the particular defendant.
All right. And there was kind of like a moment of Brennan saying, hey, it's time to end it from the criminal prosecution side, where even when the judge was saying, trying to find a date to bring her back in to sentence her on the drunk driving, he's like, listen, I just recommend, what the standard procedures. He didn't do that on his own, though. He was probably told, if this goes against us, don't prolong this any farther. He doesn't have. Does he have the autonomy to make that decision himself, or was he given that guidance by DA Morrissey?
In a case as high profile as this, I would think that he would have to have the approval ahead of time before making that decision on the spot. And I think the reason why they wanted to do that was obviously you saw the crowds gathering outside. And
you could hear the cheer. It was like a delay from probably when they were getting the word outside, but there was an audible cheer about 15 seconds after the initial not guilty, right?
I heard that on the video clip, and I have to admit, that was a little cringy because, there is a victim's family in that courtroom, and there are 12 jurors that obviously took this case very, very serious. And for them to, kind of hear celebration outside like that, I think kind of deminimizes the moment a little bit. But obviously I can see why no one would want to have to come back into the courthouse and have to provide either the protection or the security or the details to keep, all the fans at bay.
All right. So 1 year probation. She's probably going to have to, as they call it, drunk school, right? She's going to have to take classes and whatnot. But she's been without a license for a couple of years now, right?
As far as I know, yeah. So
does she get her license back right away, or do we know what comes of that? Was that made clear at all yesterday?
I didn't hear anything about that, but in my experience, yeah, it should be. If she hasn't had it for the period of time that the penalty would impose, then yeah, she should go to the RMV and have it reinstated, I would think.
Is she allowed to have it reinstated while she's being forced to attend these classes? Oh, that's the part that I'm like, well, maybe she's got to wait another year.
Well, the only caveat is this, and again, I think the file has been impounded. We don't know specifically what the terms or the conditions of her probation are. So if it's an OUI, there might be, one of the terms of her probation might be, it's still a loss of license, or she's not permitted to drive during the period of her probation. So there could be other restrictions as part of her sentence that goes, beyond whether she has a valid license or not.
All right. Which brings us to the next trial, because Karen Read is not done testifying or being a part of her proceedings. We know that the family filed a civil suit against her, the family of John O'Keefe that you mentioned. So they're still going to have to go through this. And now they're actually going to be the aggressors, the quote unquote prosecutors in the civil case. What I didn't know until you came in this morning and told me is that the bars in question are also facing civil suits from the family for over-serving her.
Yeah, so in Massachusetts, a licensee that serves alcohol has a duty not to serve a patron that they know or should have known was intoxicated. It's an old, what they call the dram shop. It's a liquor liability case. So last fall, the estate of John O'Keefe, who the personal representative, I believe, is his brother, brought a wrongful death case against in Plymouth Superior Court against Karen Read for negligence and for reckless operation of her vehicle that struck and caused the death of John O'Keefe, and also brought liquor liability claims against the two establishments where Karen Read was served and consumed alcohol in the hours leading up to what they allege was the time of the accident.
All right. You said two places. I was always under the impression, and I was told, listen, if somebody walks into your bar, your restaurant, staggering, clearly drunk, don't serve them, because it doesn't matter who served them the 8 drinks beforehand. If you serve him or her that 9th, you're the one who's legally liable, and it's your liquor license that's on the hook. I was obviously wrong, because there's 2 places getting sued here, right?
Yeah, so a successor, establishment doesn't break what they call, the causal connection. It doesn't let the first establishment or the first 2 establishments before they're, off the hook, so to say. So it's still the same standard. So they were at 2 places that night, and according to the complaint, and again, this is public record, they started off at McCarthy's, which was an establishment in Canton, and then from there went to a place called the Waterfall, and then from Waterfall, we know through the criminal trials, when they drove to Fairview, to the Albert residence. So there are allegations that at both establishments that Karen Read was overserved. So if you're overserved at the first one and that causes that person is now intoxicated, then you can still be liable for, a successor number of events up to a certain period of time.
All right. So is it a slam dunk then that in the civil trial, not going to have to work too hard? The plaintiff's attorneys, the O'Keefe family attorneys, aren't going to have to work that hard to prove she was drunk, because we already got a jury to say she was drunk in a criminal case. Is that in fact the case, or is there now going to become, is this civil trial going to be fought not on whether she hit him or not, but whether she was really drunk or not, given the fact that to our knowledge, nobody gave her a blood alcohol test or a breathalyzer, forced her to walk a line that morning, or really at any point immediately afterwards, right?
Well, with regard to the civil charges against her, she doesn't have to be intoxicated to be negligent. She could just have operated her vehicle in a negligent manner. Maybe it was backing up too fast, or not checking her mirrors, or not having a proper lookout. So they don't necessarily have to prove that she was impaired at the time, just that she struck him. With regard to the bars, though, that is a little different matter, because not only do they have to prove that the bars served her when they knew or should have known she was intoxicated, but that was a substantial contributing factor to her impaired operation and ultimately what struck John O'Keefe. So it's an easier standard. So that what makes the case a little bit easier in the wrongful death case. It's a preponderance of the evidence standard, which is it more likely than not she struck him with a car, or is it more likely than not that she was under the influence because of the alcohol she consumed at one or both of the establishments, and that contributed to the death, versus beyond a reasonable doubt. And you saw that, in the OJ case, for example. In the OJ case, he was acquitted or not guilty on the criminal, but by a preponderance of the evidence in the civil case brought against him, they felt that it was more probable than not he did actually cause the death of Goldman and
Nicole Brown
Keith.
Simpson. So yeah. I misspoke. I said she didn't get tested. She did, but it was well after the supposed 12:30 to 12:45 time period where the prosecution says she struck him with the car. And it came afterwards. And there was a ton of questions that folks were asking. Well, did she keep drinking? Did she have all that alcohol in her system at 12:45 and then still blew a .23 or whatever the next day? Or did she keep drinking when she got home and, was doing the dialing and angry texting, whatever you want to call it, and, up until they came and picked her up and brought her back to the house?
So we don't know the answers to those questions yet because she didn't say it in any interviews while the criminal trial was pending. She obviously didn't testify as part of the criminal trial. So we don't know. But as part of the civil case, she now will be subject to a civil deposition.
She has to testify. She cannot plead the fifth or refuse or not be called to the stand.
She can't plead the fifth because her charge, there's no pending criminal charges against her where she could assert that privilege. And everything is going to be fair game. And she will be asked a series of questions, not only just her background and relationship with John O'Keefe, but everything that would happened in great detail that night. From the time that she, the first established she was at up until, 5 a.m. Now, what's interesting in liquor liability cases in Massachusetts is there's a statute that requires within 90 days of filing the complaint, you have to submit an affidavit that kind of lays forth sufficient facts why the case should go forward on a liquor claim. It's not a typical affidavit where it's got to be based on personal knowledge or anything. So in this case, a month or two after the filing, the attorney for the estate filed a complaint or filed an affidavit in support. And there's reference in that affidavit that at about 5 a.m., she would have had about a .05 or even less. No, she had less than a .01, I believe, BAC at the time that she was tested. And what they cite in the affidavit is that through a chemical process, what they call retrograde extrapolation, where a toxicologist can kind of work back, how long does this take for alcohol to get out of your system? How was it processed? They have an estimate that she would have had between like a .15 and a .29 range at the time of the accident, which is a very broad range, but at least you see kind of where they're going with their case as far as how intoxicated she may have been at the time of the alleged collision.
All right. I'm going to guess that they can probably get a jury. If the last jury found her guilty of operating under the influence, they have a good chance of getting that again. But ultimately, is that going to lead to a big civil penalty? Is she going to have to shell out big bucks to the O'Keefe family if that doesn't come with the convict or the jury finding, what's the term again, preponderance of evidence or whatever, that she actually hit him and caused his death? Because it's one thing to be drunk and driving, it's another thing to hit somebody and not be, and while you're doing so. And if you weren't able to convince two juries that you did hit him, how will this play out differently in the civil case?
Well, in the wrongful death case, the jury shouldn't be asked to answer a question on whether or not she was intoxicated. It should be a very simple verdict slip. Question one, was the defendant Karen Reed negligent? And that could be, and that's a broad term, but based on the jury instructions, the judge will define, what negligence is. And we'd be like, did she operate her vehicle in a negligent manner, in a careless manner at that time? And then the second question for her would be, okay, was her negligence approximate cause of John O'Keefe's death? So that's what the plaintiffs are going to have to prove in the second case. Likewise with the establishments, were they negligent in their service? And then was their service approximate cause of the death? Obviously, some of the facts to consider would be, was she intoxicated? Was she not intoxicated? Did that contribute to her negligent operation? But they won't be asked whether or not she was. So I don't believe that that conviction and that charge will really have too much relevance in the civil trial.
Well, the science, is there any chance that we'll see different science about whether his injuries were caused by being hit by a car, in particular her vehicle? Will we start to see more evidence about dog bites and other people in the house? Or is, again, are the two teams here of attorneys going to concentrate on the forensics and the science of it?
Well, I would believe that Karen Reed's civil defense team would try to retain the same company that the criminal team used. Sometimes if you have a common defense, the other defendants could also join in, and you could have a joint defense with that one expert. If the counsel for the establishments believe that accident reconstructionist did a good job, then they may try to use that same testimony to defend in the second case, or they may go hire somebody independently.
Will she have the same defense team?
No, she actually has a different civil attorney.
Is a civil trial that much different from a criminal trial? I mean, I know it is, but ultimately it's about proving a case or not. And who knows her defense better than the guys and gals who have been doing it for the last 2-3 years? Is that?
I would just say it's the norm. You rarely see the criminal defense attorneys for a client, also defend them, in a civil case. Oftentimes it might be because in a criminal case, you personally hire the attorney. If you're being sued, oftentimes if there's, if it's for civil damages, you might have insurance coverage, and it's an insurance company that assigns, panel counsel to defend. I don't think she has insurance that applies in this case, so I don't know how she chose. Well, I take that back.
Yeah, she has car insurance, obviously, right? She has auto insurance.
That's right.
So they'll probably have some say, but she's not going to trust it to a Liberty Mutual attorney or whoever that is, who's probably going to just plead out just to not have to pay the legal fees, right?
Well, what I expect is probably going to happen is, well, first of all, she doesn't have to pay for that. It's part of her coverage. So her defense is paid for. Not knowing what her policy is, my guess would be that at some point they would just offer the policy limit to try to get out of the case. The plaintiffs aren't going to let her out of the case because they want her in that courtroom.
The O'Keefe family is 100% convinced she did it.
And again, not knowing what her assets might be above and beyond her policy limits. But I think, they're really kind of keyed in on the policies that the two establishments probably have. Because in a civil case, it's what they call joint and several liability. So if you find even one of the establishments 1% at fault, they could still pay, they don't just pay a percentage of their policy. They could pay as much as they can that would satisfy a judgment. So I think they're in for a kind of a long haul in that case. It's just getting started now. There was a motion to stay filed in the fall, kind of pending the criminal case. Now that the criminal case is over, they'll dive headfirst into discovery, which will include, written discovery, and ultimately she'll be deposed. And
it will be a video deposition, more than likely, right? We'll eventually get to see, right? We did get to see snippets of OJ's, if not all of it, at some point.
Yeah, and actually, right? Massachusetts just amended their rule a couple of years ago, where by right, if you request it, you can take a video deposition of a witness. So I would expect that hers would be audio and video recorded.
All right, so we're not done with Karen Reed legal proceedings yet, but one more question: does Karen Reed have a civil case? A lot of people have said she should sue the bejesus out of, Meatball Morrissey, as he came to be known, thanks to Howie Carr and everybody else who kind of persecuted her rather than prosecuted her. Can she turn around and sue the state and the people who?
Well, anybody can sue. The question is, would she have a case that would have merit that wouldn't be dismissed? The only thing I could think of, the top of my head, might be, is there an abusive process or a malicious prosecution case? My guess would be that's a very, very high standard, especially there's all sorts of immunity that Commonwealth, that state employees would have. So unlikely.
On that, difficult to say that, because the state is doing their job. They're just trying to find justice for John O'Keefe. But the prosecutor, the investigators, the Proctors and so on and so forth. Can she sue for them for negligence, malice, and putting her through the last 3+ years of this? Is that a case that you would advise a client to take?
And again, I believe that the police officers, the state police, would be protected and would have immunity as state employees from any civil liability against them, and that would include, I think, maybe even the city of, the town of Canton or the state police. I believe under statute would probably be immune, unless it's unless you can prove a violation of her civil rights, and I don't think the investigation rises to that level. But who knows? With this team, I think anything's on the table still, and still could be. So again, we haven't heard the last of Karen Reed.
Turtle Boy is on the case. Don't worry. He'll keep the pressure on. All right. Any other closing thoughts or closing statements after following 2 trials? Yeah,
just a final comment on the verdict slip, which I thought it was interesting. So there were 3 offenses that she was actually charged with and what this case went to trial on. Offense number 1 was the murder in the 2nd degree. Obviously the most serious charge, which the elements include whether there's an intent there to kill someone or your actions are very likely to cause serious harm or death. They clearly answered, no, not guilty to that question. Jumping ahead to the 3rd offense was leaving the scene of an accident. So this might actually, it won't come into play in the civil case, but it won't help. So offense 3 was leaving the scene of an accident resulting in death. She was found not guilty of that, which, again, they just improved that she was there, that she struck him, and that she then left. And where things got a little complicated was question number 2 on the manslaughter. They just left blank a bunch of lesser offenses, which could have been manslaughter while OUI, involuntary manslaughter. They just went down to the very last lesser offense that she could have been charged with, which was just operating under the influence, and that's ultimately where they found there was at least beyond a reasonable doubt that the Commonwealth proved the elements of that crime.
Are they allowed to leave it blank? Shouldn't there be a not guilty on those and just a guilty on the OUI?
So the problem with this verdict slip is they weren't given the option. It's an odd slip. I've never seen a slip where you're not answering yes or no, or not guilty or guilty. And they could have answered not guilty, say, on motor vehicle homicide and an instruction. If you find not guilty on this, continue on to question 5. If you find not guilty on this, either go to question 6 or you've reached the end, go back to 2, not guilty. Like I said, it was a confusing verdict slip, but ultimately it's, as a matter of law, it is sufficient. There's no inconsistencies in the verdict slip. So the verdict should be upheld.
All right. Dan Shanahan. Thank you.
Pleasure.
I learned a lot, and I may lean on you on the next the civil case.
My pleasure. Thank you.
Enjoy the rest of your day at work, even though it's a holiday. Hardest working man in Lowell.
The law doesn't sleep.
The law never sleeps. Thank you to Dan Shanahan. Thanks to you for tuning as well here to the Daily Pulse, the show where we keep our finger on the pulse of Lowell and the world around it. And certainly the world around it revolved around Karen Reed for a long time. Not over yet, folks. Thank you so much to Dan. Thanks to you. We'll be back tomorrow with Batch and Han, a reduced power hour on the Daily Pulse, where we'll wrap up the week and have some fun. Till then, everybody stay safe, stay cool out there, and I'll catch you on the other side.